Hey everybody, happy Halloween. And in its spirit, I wanted to go over one of my favorite cross sections of intellectual property and daily life, Halloween costumes. This week, a considerable number of people will don their favorite costumes, but have you ever thought, how can the Halloween store sell AFC Richmond jerseys? Or could drawing a Nike logo on your costume be considered infringement? Well, simply put, unless you're in the business of selling Halloween costumes, you probably don't need to worry about IP rights because more often than not, that one-time non-commercial use of the intellectual property is not likely to cross the threshold of infringement. What can be identified as IP as it relates to Halloween? Well, name, image, or a likeness of a particular person. This mainly pertains to the publicity rights of an individual. Unless the likeness is for commercial gain or advertising, there's probably no violation of publicity rights. Therefore, rest assured that your reimagining of Ted Lasso for a Halloween party at your friend's house is probably not likely to get you in trouble with Apple or Warner Brothers. Trademarks. As a business owner, if you intend on using any name, logo, phrase, and or design that is a source identifier of a good and or service, you probably need to sign licensing agreements with the original trademark owner. A licensing agreement is how Marvel or Warner Brothers allows Halloween stores to sell these very recognizable costumes. Therefore, recreating these protected logos or words in a homemade costume does not constitute infringement unless additional facts allude to the designer representing themselves as the trademark owner. Copyrights. Design elements of a costume are protectable under US copyright law. Copyright protection is prevalent in masks and costumes, but does not extend to their functional features. Let me explain. For example, a costume's pant leg opening or armholes, because they are functional, are not eligible for copyright protection, but the design elements are protectable. In the famous case Star Athletica v. Varsity Brands, the Supreme Court decided that if a design can be perceived and imagined separately from the functional features, it is eligible for copyright protection. US copyright law focuses on commercial gain, and as long as your costume was made and used for personal use, the use of the copyrighted material is likely considered a fair use. This is a gentle reminder that intellectual property is always present in our daily lives, be it the food we eat, the media we consume, or the costumes we wear to scare the crap out of the neighbor's kids. If you ever need assistance with licensing agreements or other trademark or copyright issues, feel free to connect with me through the provided link in the description or by going to www.drishtilaw.com. As always, this is Sahil Malhotra, and thank you for watching.